Hi, hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today in this company law, let us learn about the very important topic Doctrine of Ultra-Vires. What are the consequences, etc. As we all know that the company is capable of doing only such acts that are authorized by the Companies Act 1956 and any other law in force, and it is only allowed by the objects clause of the Memorandum of Association, and it should be doing such acts which are consistent with the laws of the land. The rationale behind this restriction on company's power is to protect the company's shareholders and creditors by ensuring that the company's funds are not squandered in pursuing illegal activities. So the doctrine of ultra-vires provides that those transactions of a company that are beyond the scope of the Memorandum of Association or which are against the provisions of Companies Act 1956 or 2013 or the general laws of the land are ultra-vires. So these ultra-vires transactions are therefore null and void so far as the company is concerned and cannot be ratified or validated by the entire body of shareholders. If any acts which are against the policy of the law of Companies Act 1956 or 2013 or which are not there in the objects clause of a memorandum or which are not consistent with that law of land, that is in which country that company is established, which is against that law, that is completely ultra-vires. This doctrine is beautifully explained in the case of Ashbury Railway Carriage and Iron Company Limited versus Rich. Here what had happened is, in the memorandum of association of this company, the objects clause says that the company is only used for making, selling or lending on hiring railway carriages and wagons, and it is only used for the carrying of business of mechanical engineers and general contractors for purchase, lease, work and sell mines, minerals, land and buildings only. But the directors of the company entered into contract with Rich for financing of the construction of a railway line in Belgium. They did for financing of the construction of railway line in Belgium. And it was also ratified by majority of the shareholders. Later the company repudiated the contract, that they will not continue the contract. So this Rich sued the company for breach of contract. So the Rich contended that the agreement between him and the company for financing of the construction of railway line in Belgium would come under general contracts of the objects clause of the company. Therefore, the contract was within the limits of the objects clause of the company, and he also said that, and majority of the shareholders also ratified the contract. But the judgment came that the House of Lords held that the contract between Rich and the company was like an ultra-vires which is against the objects of the company, and it dismissed the suit of Rich. And the House of Lords also observed certain principles while making a judgment. They said that a statement of an object has twofold operation. It states affirmatively the ambit and extent of the power of the company, and it states negatively that nothing shall be done beyond the ambit. Here the term general contracts must be taken to indicate making generally of such contracts and are connected with the business of mechanical engineers and not for financing of any type of construction. So from this case law we can easily understand that anything which is beyond the objects of the clause of the company, if anything is beyond that, is ultra-vires. Let us look into the main objects of the rule of construction. Sometimes the companies include very conceivable kind of business in their memoranda so as to get over the hardships created by the doctrine of ultra-vires. In such cases, the court applies the main object as the rule of construction. This rule is applied to identify the main business of the company and all other businesses which are considered nearly ancillary to the main object. So we can easily get it from this case law, German Date Coffee Company. In this case, this company was formed with the main object which is having an object in the Memorandum of Association that it would produce coffee based upon the German patent, and that would be granted for the manufacture of coffee from dates. So ancillary objects stated that it would also obtain other patents for improvements and extension of the invention and acquire and purchase any other invention for manufacturing company. However, the company could not succeed in getting a German patent. In failure to obtain German patents, it purchased the Swedish patent and started manufacturing coffee from dates. So two shareholders challenged and sued the company for its winding up as its purchase of Swedish patent was ultra-vires to the main objects clause of the MOA. The judgment came in this way. The main object of establishing German date coffee was to manufacture coffee from dates. It held that the main object could not be achieved and therefore it ordered the company to wind up under just and equity. So, the ancillary objects should not be considered first here. The main object first it should be considered and then the ancillary things. So, when it cannot fulfill the main objects, the ancillary objects will become null and void. Let us look into where is this ultra-vires getting distinguished. Ultra-vires, the directors. Any act or transaction beyond the powers of the director but within the powers of the company. For instance, directors can make a gift to an employee while they have no authority to do so. Ultra-vires, the articles, that is an act or transaction which is beyond the scope of the articles of the company. For example, where a higher rate of interest is allowed on calls received in advance than what is provided in the articles. In both these cases, company can ratify them by means of resolution of the general meeting. In the case of articles, the company may alter them with the retrospective effect. So, what are the further effects of ultra-vires transaction? Number 1, injunction. Any member of the company can bring an injunction against the company restraining it from proceeding with the ultra-vires act. So, if any member has observed that this company is making contracts which is ultra-vires, which is an ultra-vires transaction, then he can bring an injunction against the company to stop it. Personal liability of directors. The funds of the company can be applied carrying out only authorized uses only. The directors are personally liable to the funds of the company which have been used for the ultra-vires purposes. And what is the liability of directors to third parties for breach of warranty of authority? So, we know that directors are the agents of the company and as such they are expected to act within the limits of the company's powers. If they induce an outsider to contract with the company in a matter which is beyond the company's powers, they would be personally liable to the third party for their loss. In this case, the directors are personally liable only if their acts amount to an implied misrepresentation of facts and not of law. For example, when a memorandum doesn't authorize the directors to borrow at all, it is a question of law that every lender is supposed to know that he cannot hold the directors liable. And next is the ultra-vires acquired property. If the company's funds have been spent on ultra-vires and acquiring some properties, the company's right over the properties is protected. The reason is that an asset, though wrongly acquired, represents the corporate capital. Next is the ultra-vires contracts. A contract that is ultra-vires by the company is wholly void and has no legal effect because the company has no power to make them. The company can neither sue nor be sued by them. Any ultra-vires contract cannot become an intra-vires by any reason of estoppel, lapse of time, acquiescence, delay or ratification. So, all these are the effects of ultra-vires of the company which are done either by the members of the company or any other shareholders. As such, we have come to the end of the session. It's riddle time. Please answer the riddle in the comment section. Please like, share and subscribe. Thank you.